Hi, I'm David Fowler with the Constitutional Government Defense Fund, the litigation allied arm of the Family Action Council of Tennessee. And I want to say to the pro-life community here in Tennessee, we got a great victory yesterday, Thursday, from the Sixth Circuit Court of Appeals, holding constitutional the 48-hour waiting period before an abortion can be performed. We want to give a special kudos to Sarah Campbell, who in the Attorney General's office argued this case in front of the Sixth Circuit Court of Appeals. We also want to give a special shout out to Alex Rieger, who tried the case in front of the district court and was responsible for the evidence that was put into the case that actually became important to part of the decision, and you'll see why in just a moment. But as a part of our responsibility to make sure people understand what courts are doing on complicated constitutional issues, I want to make it clear over the next couple of minutes why the decision of the Sixth Circuit Court of Appeals is not any kind of foundation for overturning Roe versus Wade. It's not a precedent that would lead to the overturning of Roe versus Wade. And to say that this is a foundation for, and the groundwork was laid for overturning Roe versus Wade by this decision is just actually not true. So let me explain why that is the case. When plaintiffs like Planned Parenthood bring a lawsuit, they will often bring two kinds of claims. The first is what's called a facial challenge. They'll say that no matter who the law actually applies to, on its face, it's unconstitutional. So what would that mean? Well, think of a law that says African Americans can't register to vote. Well, it's just unconstitutional. It's barred by the 13th, 14th, and 15th Amendments, right? So it's just wrong. It's unconstitutional. There's no question. Okay, so that's one kind of complaint. And what they were saying is that this law is so wrong, it doesn't matter what the particular women are or what groups they fall in. It's just unconstitutional. You just can't do this, period. Okay, that's the first challenge. The second was as applied. That, in other words, while the law on its face may look like it's okay, when you actually go to apply it to certain particular people, the evidence will show that it violates their constitutional right. That's called an as applied challenge. Now, let me work through this. And you'll see why the decision of the Sixth Circuit is not any kind of precedent or ground laying for the overturning of Roe versus Wade. So as to the first, the as applied challenge, here's where the court began its opinion. Let me just quote it so nobody will misunderstand my intentions or think I'm trying to be political about it. Quote, "We are starting by explaining the relevant legal standard. A law regulating abortion is facially valid." See, in the context of claiming it's facially invalid, the court's saying, well, it's facially valid if it meets two requirements. One, the law is reasonably related to a legitimate state interest. Well, the court said, of course, the state has an interest in life. It has an interest in the health of the women, making sure women understand what they're doing, the fetal stages of development, and so on and so forth, and the implications. Yeah, that's a legitimate state interest, no problem there. But the court continued. And, to be facially valid, the law does not place a substantial obstacle in the path of a large fraction of women seeking an abortion of a non-viable fetus. So, let's look at what the court said about that. What does it mean that if the law doesn't affect a large fraction of the women who want abortion, well, then it's okay. So here's what the court said. The year before Tennessee enacted the law, its clinics performed 12,373 abortions. And the year after Tennessee enacted the law, its clinics performed 11,235 abortions. And the next 2 years also saw abortion numbers in the state hover under just 11,000. So, while abortions declined slightly by about 9%, the law did not keep a large fraction of abortion seekers from obtaining the procedure. Now, we're really delighted that potentially 9% of the people who would have been aborted weren't aborted. But the court's saying that's a small percentage of the people wanting abortions, so that's not a substantial obstacle. But when it comes to a heartbeat bill, or a bill that says you can't have an abortion after 6 weeks or 8 weeks or 10 weeks, well, that's a large fraction of women who would be impacted. In fact, a heartbeat bill, the argument is, affects virtually all women, so that would be a large fraction. So this part of the court's analysis has nothing to do with laying the groundwork or a foundation or establishing any precedent that would help lead to the overthrow of Roe. It just doesn't. Now, what about the as-applied challenge? The court said, and again I'll quote, The plaintiffs claimed in that brief, the brief they filed, that the law, even if valid on its face, is unconstitutional as applied to certain groups of women. And here they were, I'm quoting. Women who will miss the cutoff date for an abortion because of the 48-hour waiting period. What is that? Well, that's women who, if they have to wait for 48 hours, and maybe they can't come back exactly at 48 hours because the clinic's not open or they have to travel too far, well, the next thing you know, they're into the fetal viability stage, and then they can't have an abortion. 2, women whose medical conditions increase the risk of delaying the procedure. So when you apply the 48-hour period, generally, okay, that's fine. But what if it increases the risk of harm to you as a woman? Unconstitutional as applied. 3rd, women who are survivors of rape, incest, or intimate partner violence. Well, we should have an exception in the Constitution for that, regardless of, and no waiting period should apply there. Here's what the court said. But the plaintiffs failed to identify any discrete and well-defined instances where women in these groups faced or were likely to face a particular burden because of Tennessee's waiting period, the foundation for an as-applied challenge. In other words, if you're going to say the law applied to these particular kinds of people would be unconstitutional, then you have to put in some evidence that there are those kinds of people, that somebody has in fact been affected by it, so that the challenge would succeed. The court's next sentence: the lack of evidence is fatal to their as-applied challenge. So, in other words, they didn't put any evidence, so they lose. Had they had evidence, well, maybe they would have won. We don't know. But because of the court's rationale for disposing of both the as-applied and the facial challenge, we don't have any kind of foundation for saying this can help lead to the overthrow of Roe versus Wade. And I hope that helps you understand what the Sixth Circuit did and did not do.